Good evening, and welcome to St. Thomas More for the 11th annual Judge Guido Calabresi Fellowship in Religion and Law. I want to express my gratitude to the L.L.M Institute for their generosity in making this event possible. Because of a conflict in schedule, Lou L.L.M could not be here tonight, but he assures us of his support and goodwill. He is very much with us in spirit. The support of many alumni and faculty have made a tremendous difference here in the last several years that we've expanded our programs. And I'm especially grateful to Lou L.L.M and Guido Calabresi for all they have done and continue to do for this community. The Calabresi Fellow for 2017 is Dieter Grimm. Professor Grimm is a professor of law at Humboldt University in Berlin and a visiting professor of law at Yale Law School. He has served as a justice on the Federal Constitutional Court of Germany. He holds law degrees from the University of Frankfurt and Harvard. His most recent publications in English are Constitutionalism, Past, Present, and Future, and the Constitution of European Democracy. After his lecture, remarks will be offered by Professor Patrick Weil, Senior Research Scholar in Law and Visiting Professor of Law at Yale Law School. He is also a Senior Research Fellow at the French National Research Center in Paris. His recent books are Dual Nationality, Social Rights and Federal Citizenship in the U.S. and Europe, The Reinvention of Citizenship, and The Sovereign Citizen, Denaturalization and the Origins of the American Republic. At your places, there is a more detailed bibliography and description of these two distinguished professors. I call that paper to your attention. After Professor Weil's remarks, there will be some time for audience questions. Please line up at either microphone to ask a question of either our speaker or respondent. The title of tonight's lecture is The Right of Muslim Women to Wear Headscarves, Law and Religion in the European Court. Please join me in welcoming Dieter Grimm.
Thank you very much for the invitation to this prestigious lecture in the name of Guido Calabresi. He was the one who approached me and asked me whether I would be willing to give the lecture, and of course I accepted with pleasure. Ladies and gentlemen, the Muslim headscarf is not the only and certainly not the most serious problem of increasingly multicultural societies. But it has become a symbol for the conflicts that such societies increasingly face. I think for immigrant societies like the United States, this is a well-known problem for a very long time. For many European countries, especially those that were not colonial powers, it is quite new. And this is also true for my own country, for Germany. And I can say that we certainly have not yet found a consensus on how to handle these problems. Rather, many of European societies are drawn back and forth between two extremes. On the one hand, total assimilation of migrants from different cultures and different religions that come to Europe. On the other hand, an unlimited recognition of cultural and religious habits that they bring from their own countries. However, when the problem reaches the courts, and I'm supposed to talk about the legal aspects of the problem, which are not the only aspects, of course. When the problem reaches the courts, what, by the way, they more and more do, the extremes are not at stake. In court, these problems present themselves in the form of concrete conflicts between certain religious commands and certain secular laws, which usually do not have any religious connotation for the native population, but may well have a religious connotation for the migrants with a different cultural and different religious background. And this is also true for the headscarf. When it is worn in public, and especially when it is worn in state institutions, and even more so when it is worn by state agents, civil servants. Here, religious commandments very often collide with the principle of the secular state. What is the secular state? I think the secular state is the type of state that has dissolved its bonds with religion, claims independence from religious truth, no longer derives its legitimacy from God, bases its power on worldly grounds, doesn't feel responsible for the eternal salvation of the citizens, but pursues the common good of a worldly nature. This does not mean that religious truths lose their right to existence in the secular state, but they cannot claim validity for the society as a whole. They have to stay within the framework of the public order. The state's non-identification with a certain religion, I think, is the precondition for the state's ability to guarantee peaceful cooperation and peaceful coexistence between groups that have different truths, believed in different truths that for them have an absolute value. However, one cannot conclude from what I just say only within the secular legal order. One cannot conclude from this that the secular order always trumps over religious commands. The public order in a constitutional state comprises freedom of religion, and secular laws and the application of secular laws have to respect this freedom. And courts cannot escape this demand, what they, by the way, are often inclined to do by telling believers what their true religion is, or telling believers that they misunderstand their own religion. For instance, that the headscarf has no basis in the Quran. The state has no competence to determine what religious demands are and what the content of a religion is. The freedom of religion protects what a person believes to be its truth, its religious requirement. However, protect doesn't mean necessarily allowed. Freedom of religion is neither an absolute right, nor is it the only right. It can be abused. It can exercise in a way that creates harm to other people. It can enter into conflict with other fundamental rights. And this means that some sort of accommodation has to be found between religious commands and secular laws. Before I come back to the headscarf, I would like to put this problem into a little bit larger framework. And I want to do it by describing in which form conflicts between religious norms and secular laws usually arrive when they come to courts. And I would like to distinguish between two major claims that are based on religious freedom. One is the claim for more freedom than the general laws grant in favor of religion. The other one is the claim for a restriction of fundamental or of freedom that general laws grant. And for both groups, I have two subsections, so altogether 4 categories. The first group, the claim for more freedom in favor of religion than the general laws allow. This comes in 2 forms. The first one is the right not to do what the general laws require. So, to give an example, a sick motorcycler is by secular laws obliged to wear a helmet. Religiously, he is obliged to wear the turban, and both things do not together. So how do we accommodate this? Or another one, not to send the right, the claim not to send children to school, but to educate them in private circles. The second one, the right to do what the general laws prohibit. Example here perhaps, which comes up in many societies, the ritual slaughtering of animals, or polygamy. So this was the first group with 2 subsections, more freedom. The second one is less freedom for religion's sake, also in 2 forms. The right to forbid believers what the general laws allow. Divorce, for example. Blood transfusion, for example. And secondly, the right to require from believers what is optional according to the secular laws. Here we are in the area of dress requirements, food requirements, but it can concern more important problems like duty to marry, if a religion imposes such a duty to marry a person that is not the person of one's own choice. I could introduce more categories because up to now I talked only about claims that are based on freedom rights. I could also form, again, 4 groups that are based on equality rights, but this does not apply to the headscarf, and I don't want to make things too complicated, so I leave the equality claims out. By the way, it's almost always impossible to reframe freedom claims into equality claims and the other way around. Okay, my question is, how do we handle these conflicts? And as radical solutions are not available, neither in favor of the general laws nor in favor of freedom of religion, some sort of balancing is inevitable. What do we balance? Not the big values. We don't balance religion versus secularism. Each case that arrives in a court comes in a concrete way. It implies a concrete, a specific restriction of religious freedom, and there is a justification by a concrete or a specific public interest. So what we balance is gains and losses. How heavily weighs a loss for a religious freedom if the secular laws prevail? How heavily weighs the loss for the public interest if religious freedom prevails? The outcome depends on the circumstances of the case. Sometimes balancing will lead to an exemption from general laws. Sometimes balancing will lead to an application of the general laws at the costs of religious freedom. The existence or the examples of the first subjection that I mentioned, more freedom, the helmet example, will probably lead in almost every legal system that I know, will almost always lead to an exemption from the general laws. Why is that so? I think the fact that the requirement to wear a helmet if you participate in traffic is mostly in the interest of the person itself. It protects the person from itself. It doesn't protect others from harm. So in this case, I think it is easy to give an exemption from general laws. I realize there are also taxpayer problems involved because someone who is hurt because not wearing a helmet may put a burden on the public budget, but I think the protection of the person against himself is in the foreground. So exemptions will be possible. I could hardly imagine, at least for the European countries that I know, that a claimed right not to send children to school would find support, but I know that the US Supreme Court granted such an exemption with regard to the Amish. Hardly imaginable that it would happen in a European state. And probably it were the specificities of the Amish group that allowed the Supreme Court to grant this exemption. In the other second subsection, ritual slaughtering, the court of which I used to be a member granted an exemption if it was possible to use the least intrusive means for the animal that is slaughtered. I can hardly imagine that the European court would grant an exemption for polygamy, because there are quite a number of other things are at stake. Much more difficult is the second big group, the group where religious demands, religious beliefs require a restriction of freedom that is generally given. This claim means that religious groups, or sometimes parents or sometimes husbands, accorded the right to restrict a freedom of the member of the group. But there is a fundamental difference between religious commandments and secular laws. Secular laws claim compliance regardless of whether the addressee likes them or doesn't like them, regardless of whether the addressee agrees or does not agree. Religious commandments, the obedience to religious commandments must always be voluntary in the light of secular laws. A secular state, is not permitted to adopt laws for which only a religious justification and not a secular justification exists. And the secular state cannot grant religious groups the right to use force, and the secular state cannot lend the state's force to the enforcement of religious commandments. So the sanctions that religious groups have are always inner religious sanctions, so to excommunication in the Catholic Church, to use this example. But there are limits even where voluntary compliance with religious commands exist. There are even limits in this case, namely if the religious commandments contradicts the very essence of the secular order of a certain country. And I think this finds its application predominantly in the field of gender equality. But also where dignity is concerned, where human dignity is concerned, a restriction can, even if it is taken upon one's person voluntarily, not be granted. Less problematic is the second subsection, the subsection where we are in the field of dress requirements, food requirements, etc. A religious community would like to prohibit what the general laws leave optional. And therewith we are back with the headscarf. The headscarf is not a harm in itself. I remember in my childhood after World War II that usually, we were rather poor at that time, German women wore headscarves. They were not framed in the way that the Muslim headscarf is framed, but it was totally normal that women wore headscarves. So the headscarf is not a harm in itself. If it becomes challenged, then if it challenges the secular character of the state, there must be something in addition. And I think that the attitude that various legal systems, various countries adopt vis-à-vis such challenges depends very much on the understanding of secularism. And the understanding of secularism is by no means the same in all European countries, and certainly not if we go to the global level. We usually distinguish three spheres: the private sphere, the public sphere, and the sphere of the state. The private sphere doesn't pose any problem. I think that in the private sphere the headscarf is not worn, but I think that also no state purports to regulate the private sphere with regard to dress. But the public sphere already sees a lot of differences. The French understanding of secularism and the display of secular symbols, behaviors, acts in public is a very different one from the German one, to take these two examples. I will not dwell on France because Patrick Weil is there and he is the authentic interpreter of the French system. But the German system takes a much more lenient approach to religion in the public sphere. It has no problem with religious activities, religious symbols in the public sphere. According to our understanding of fundamental rights and of freedom of religion, the state even owes protection to religious groups and religious activities in the public spheres. That does not mean that we don't have any problem at all in the public sphere in the German system. But the problems that we have are usually not problems where the state is involved and puts limitations on religious activities, but these are cases that arise out of labor law. So employers try to prevent employees from wearing the headscarf. This is a totally different set of problems in the private sphere to private actors and the state not involved. In Germany, I know only of 5 cases in which my former court, the German Constitutional Court, rendered decisions in this area, conflict between secular norms and religious commandments. And I will very briefly describe them. The first 2 concern the area where the clash between the two happens most frequently, in my view, namely in school, in education. In Germany, the problem appears only with regard to teachers. There are other countries where the problem is it allowed to wear the headscarf or not, also applies to students, pupils. In Germany, only teachers are concerned, and we have 2 cases where teachers were involved. Muslim women who wanted to teach in German schools. And I have to say it also applies only with regard to public schools, not to private schools. Denominational schools would not be affected. But in Germany, almost all schools are public schools, state schools. So there the problem arises. And This were 2 cases regarding school. Then we had 1 case regarding what in Germany is called a Referendar. Referendar is a trainee for legal jobs, so to say. After your law degree, you are obliged to undergo a practical training of between 2 and 3 years. And during this time, one is acquainted with a lot of legal professions. One spends also some time in court. And it may even be that some minor judicial activities are handled by a referendar. So the case came up. Is a Muslim woman referendar allowed to wear during these activities the headscarf? The 4th case concerned a daycare center where a Muslim woman was active and she was prohibited from wearing the headscarf. The last one is a labor law case, a saleswoman in a huge department store who, according to the will of the employer, should not wear the headscarves. Before I briefly say how these cases were decided, I would like to mention a case that has nothing to do with the headscarf. It has nothing to do with women. It has nothing to do with Muslims, with the Islam, but it has something to do with religion and religious symbols. And it was the case, it was at the time when I was a member of the court, it was the case that perhaps was the most controversial case that the court ever decided, and it drew a lot of protest. which continued for weeks, and prime ministers and bishops marched in front of demonstrations. And this was the case about a Bavarian law that required a crucifix to be displayed in every classroom of elementary schools. And this was challenged, this rule, this law of Bavaria was challenged by atheist parents and their children. And they had a number of children, I think they had 5, so that whenever a child came to choose the problem arose anew. Now, the question was, what does the crucifix symbolize? What does it stand for? If it doesn't symbolize religion, if it doesn't stand for religion, it cannot infringe into atheists' right to freedom of religion. So this was one of the crucial questions in this case. The lower courts, case worked its way up from the lower courts. The lower court said it depends what it symbolizes. It is a Christian symbol for the Christian pupils. It is some general cultural symbol for the atheists or those from other religions. Even more so, the Bavarian government argued in the Constitutional Court, it depends on what is taught in the classroom. So if the math teacher is in the classroom, it is a general cultural symbol. If the religion teacher, religion is a course taught in German schools, then it is a religious symbol. The Constitutional Court was divided. The minority, 3 out of 8, said in school buildings the crucifix is no longer a Christian symbol. It's a general cultural symbol of the Occident. The majority, 5, said if there is a symbol that symbolizes Christendom, it is the crucifix. And the consequence was that the order to display the crucifix in every classroom means an identification of the state with one religion, and this was unconstitutional. It was declared unconstitutional. The crucifix had to be taken away. Now, I brought this example in order to contrast the headscarf with it. What symbolizes the headscarf? This is much less clear, I think, than the question, what does the crucifix symbolize? You get many answers if you look around. It symbolizes the Islamic faith, very often. It symbolizes the belonging to a certain culture of the Muslim world. It symbolizes the protest against the sexualization of regarding women as objects of sexual desires. It symbolizes the suppression of women. It symbolizes political Islam, even fundamentalism. All this, and I think more, answers you will get when you ask the question, what does the headscarf symbolize? Now, of course, the question, is the headscarf allowed or not, cannot depend on the motive out of which a certain person wears the headscarf. It depends much more on the perception by others who are exposed to this symbol. That's to say, it depends on the perception of the students, the parents. If we take the case of the referendar in court, it depends on the perception of the parties to a litigation or to the audience in the courtroom, etc. So let me look, and this brings me already close to the end of what I have to say. Let's have a look how the courts decided these cases. The first case concerning school teachers was decided in 2003. A Muslim woman that otherwise qualified for a position as a school teacher was not hired because he refused to teach without the headscarf. And this is why she was regarded as inapt for civil service. The Constitutional Court differentiated this case from the crucifix case. It said the crucifix is unequivocal in its meaning. The headscarf is not unequivocal. If the state tolerates that certain teachers wear the headscarf in school, this is not this degree of identification of the state with a certain religion as it is with the displaying of the crucifix. Yet, the court said, it is possible that wearing the headscarf in school poses a threat. There can be reasonable fear of indoctrination through the teachers who wear the headscarf. So, what the court said is the general principle that only a person can be hired for civil service who has the aptitude, the necessary aptitude, is not sufficient as a basis to prohibit wearing the headscarf in school. What is needed is a law that specifically addresses this question. And therewith, the case was back in the political sphere, and the legislatures of the various German states — school is a matter of states in Germany, not of the federal government — the parliaments had to decide what to do about this question. The second case of schooling came 2015, and now these laws existed. And the law that had to be reviewed allowed prohibited the headscarf, not only the Muslim headscarf, but prohibited the exposure of all religious symbols and symbols of philosophy or general world attitude. The court upheld the law by requiring a narrow interpretation of the law. The court said merely abstract danger, that wearing the headscarf could create a problem, is not sufficient. There has to be a concrete danger, that's to say something in addition to merely wearing the headscarf. Teaching position is used for indoctrination, for instance, general behavior possibilities. So in this case, the law was upheld, but it was considerably narrowed. I mention, by the way, because it's rather strange, the court was not under a constraint to decide this question, because the two women that brought the individual complaint, one was active in a school, but she was not a teacher, but she was a mentor for school conflicts. So it would have been easy to say that there is no ground to decide this case. The second one was even here. She was a Muslim woman who taught in school, but she had agreed not to wear the headscarf, but instead a woolen cap. So it would have been easy for the court to say these are clear cases, but apparently the court wanted to decide the bigger question. Number three was the referenda, and there the court said, and I think this is absolutely correct, that when a referenda exercises judicial functions, questions a witness, or sits on the bench and takes the minutes, or things of that sort, then it is prohibited to wear the headscarf. Outside of judicial activities, this is no problem. A person in a daily care center was no problem at all. This was a chamber decision for minor problems, and the court didn't see any danger in a child care center. And with regard to the saleswoman, the court decided that the interest in freedom of limitation outweighs the interests of the employer. But in this case, I have to add that only a few weeks ago, the European Court of Justice, this is the court of the European Union, had to decide a similar case. And the European Court said on the side of the employer, freedom or economic freedom, freedom of profession is at stake. And on the side of the woman, we look whether the prohibition of the headscarf is a discrimination because of religion. And the court said, yes, it is an indirect, it applies to all religions, but it's an indirect burden for this woman. But this indirect burden doesn't outweigh the economic interests of the employer. The European Court of Human Rights, European Union started as a common market, and still economic interests gain a special interest in the Court of the European Union, very often over other interests. I want to ask for your attention for one interesting case, and it's the last one, and it's not Germany, it is Turkey. Turkey is a laical state, but has a religious society, a completely religious, more or less homogeneous religious society. According to Article 2, Turkey is a laical state, and this rule in the Turkish constitution is unamendable. So even with 100% majority in parliament, it couldn't be amended. You would have to do away with the old constitution in order to get rid of the principle of laic state. And the principle of the laic state in Turkey was understood as prohibiting the headscarf in all public buildings and in all educational institutions, not only in schools, but also in universities. So this was seen as incompatible with the principle of laicism. Now, from time to time, and the case is now again there, from time to time, conservative parties, Islamic parties, had the majority in parliament, and they were opposed to the ban of the headscarf. And there were two attempts to abolish it in schools and universities. Universities were the case where the problem escalated most. The two laws were declared unconstitutional by the Turkish Constitutional Court. The European Court of Human Rights, now this is not the Court of the European Union, this is the Court of the Council of Europe, where all 47 European states are members. The European Court of Human Rights found with 16-1 votes that the ban was no violation of freedom of religion, preserving the laical character of the Turkish state was found to be of extreme importance for Turkey. It was regarded as a legitimate purpose for such a restricting law, and the court even combined it with the danger of fundamental Islamism, and it also took into account that allowing the headscarf would put pressure on those Turkish students, scholars who wouldn't like to wear it. Now, from 2003 on, we have the Erdogan government in Turkey. That's to say, a conservative, religious political party. And this party knew, of course, that the attempts of the legislature to change the law had failed in the Constitutional Court. So the Erdogan government said, well, then, constitutional amendment. And they passed a constitutional amendment in 2008, which abolished the ban. And this constitutional amendment was declared unconstitutional by the Turkish court. Article 2, laic character, is not amendable. There is one tricky moment for lawyers who like these things. The Turkish court is permitted to review constitutional amendments as to their constitutionality, but only with regard to the form. That's to say, was the procedure correct, was the majority necessary, but not with regard to substance. Now, the question is the headscarf compatible with the Turkish constitution, Article 2, is of course a question of substance. So how did they get around that? They got around that because the law said, the law that determined the powers of the Turkish Constitutional Court, the court, no amendment may be brought that regards the unamendable sections of the Turkish constitution, and no such amendment may be proposed. And the court said, proposed is not substance, propose is form. And so they said this amendment could not be proposed and then, of course, not voted upon, and it was declared unconstitutional. Now, it was 2008. Beginning with 2010, after a constitutional amendment that concerned the composition of the Turkish Constitutional Court, we see a continuous abolition of the ban on the headscarf. And the most recent part, I think probably the last one, is that a few weeks ago, female soldiers were allowed to wear the headscarf. Nothing so far by the Turkish Constitutional Court, and I think, this is my guess, it's not my certainty, but it is my guess, that by the amendment of 2010 that changed the composition of the Turkish court, this court has been tamed. And it's not the only court in recent years that has been tamed by politicians. Even member states of the European Union face this happening. Okay, it's now the turn of Patrick Weil to add more aspects to this brief account. I think what we have seen is that the question is by no means settled, certainly not in the societal sphere. The wave of migrants that is flowing to Europe, 2015, nearly 1 million refugees coming only to Germany. The wave of migrants fuels the problem anew. Nationalist political parties emerge in many countries, recently also in Germany. Legally speaking, I think balancing, or to be more precise, applying a proportionality test when it comes to review laws that ban the headscarf are a good tool, a suitable tool to solve these problems. And I see no better alternative than balancing in the individual case when these problems come up. Thank you very much.
Thank you very much, Dieter. Thank you very much, Guido, for inviting me, and thank you very much to the team of the St. Thomas More Chapel. So I will start where you ended, because if you look at the European jurisprudence on headscarf, it started with Turkey in the 60s. In fact, because Turkey was, as you mentioned, a laical, which the word doesn't exist only in Turkish and French, laïcité, laical. It came from the French laïcité. There was the affirmation of the secular state, and it was cases coming from a Muslim country where the court reaffirmed the ban on wearing this religious sign very early in the jurisprudence of the court, much before we had the cases coming from Western Europe related to minorities. So that is interesting to notice, because what it shows the incredible diversity of the European situation for the court, for the European Court of Human Rights and for the European Union Court, which obliged the court to apply strongly its concept of margin of appreciation, depending on every country. And of course, I would like first to try to frame a little why some cases, for example, Dieter mentioned in Germany, we don't have cases on students wearing the scarf, which was probably meaning not like in France, where we don't have cases on the teachers. And why? How does it come from that? So I think it comes from the different historical borders that has been set between the different sphere and the place of religion within each sphere. So if you take, first of all, every country of Europe give a special protection to religion. Even the most secular atheist give a special protection to religious practice. Nevertheless, one has to distinguish, when we speak about the jurisprudence, between the law and the jurisprudence on one side and the majoritarian social belief. Let me give you an example, which is an American example. In this country, you can burn the Bible or the Quran. Nothing will happen to you. Blasphemy is constitutional. But if you suggest any doubt about the existence of God, you might not run for a presidential election because you might not be elected by your compatriot, who will not trust you as a good president. So what is interesting, it has in my country, France, because we don't have established church, because we have maybe a stronger separation than the US, the law and the jurisprudence resemble a lot to the American jurisprudence. But the belief of the population is the opposite. The majority of the French don't believe in God, even if we are from a very old Catholic country, and with the old tradition of Catholicism. And it is the people, so here some people will not trust the atheist. In my country, some people will not trust the believers, thinking that they are backward and they have not been illuminated by the Enlightenment. And so you have this perception, and I would like to add something which comes from a conversation I had with an American colleague, in the triangle that exists everywhere between the individual, the religious group, and the state. For historical reason, in the United States, the religious group appears as a protector of the individuals toward the intrusion of the political power, of the state power. As in my country, it is the state which appears a protector of the individual against the intrusion of the religious group, which was dominant, which was the Catholic Church. And the law of separation that came strongly in 1905 and led to the break of diplomatic relation between the Vatican and the French Republic was due to the fact that the Catholic Church was fighting against the Republic or for the guilt of Dreyfus, intruding itself in the public affairs of France. So that makes the French having a kind of prejudice that when there is a conflict, there is always the idea that when you have to think about the freedom of conscience, which means freedom to exert religion, but also freedom to be free of religious pressure, there is always the perception that what is at stake is the religious pressure, because of the history of the country. And so I think the best thing for me is to give you shortly the story. I have been part of the commission that proposed the ban on religious sign in public school. So in a few minutes, I can explain how we proposed that, and then what was the fate of the proposal. So the story, I totally agree with Dieter. We cannot give a meaning, and it's not the role of the law to give a meaning of what is a scarf. It can be many other, in addition of the one you mentioned. It can be revolt against secular parents, it can be protection, it can be anything. So you cannot give a meaning. What happened is that we noticed, because of the complaint of the teachers in public school, that group of female Muslims not wearing the scarf were pressured, sometimes violently, by a group of males who would tell them, look, your sister across the courtyard wear the scarf, it's legal to wear it. You have the freedom to wear it. So if you don't wear it, it's because you are a bad Muslim. So because you are a bad Muslim, we are going to take care of you at the time of the break, etc., etc. So you had bullying on the Muslim girl not wearing the scarf. And that was coming from the ground of the teacher. What do you do? So we were told, go after the boys. Okay, we go after the boys. The boy deny, etc. Then the violence continue. They are excluded from school. Then the parents go to court. My boy has been excluded from the court unfairly. So then you need witnesses. Who are the witnesses? The kids of 12 and 13 years old? You cannot transform the courtyard of a high school in a court. And even in the US jurisprudence, you have special limitation of rights and you have special duties for minor children in high school. They are not submitted exactly to the same rule than the adult world. So what could we do in that situation? So we need to take into account the particularity of the French secular system. Officially, we are very secular, separation between, and for example, because of the separation with the Catholic Church, the civil servant cannot wear any sign. So the battle is on the ground of the high school and it cannot be in the teacher's issue. But since 1959, the French taxpayer pay for the teaching in Catholic schools, for the teaching of the kids who are attending religious school on the contract. There are two conditions for that they have to follow the national curriculum, and secondly, that they have to be open to students of any faith. So the only part of the tuition the kids or the family pays is the religious teaching. The rest is paid by the state, by the taxpayer. And of course, the religious students, Catholic, Christian, go to these schools and follow the same curriculum. So we thought, let's ban the cause of the trouble and let's favor that the Catholic or the other religious school or the Muslim, there are very few, permit access to the girls who want to wear the scarf. They can still, of course, they have to go to school. And it is what happened. Today, after the ban, the majority of the Muslim girls who want to wear the scarf attend Catholic schools. You might think it's crazy. Rationally, it doesn't function very well, but the French people like it very much. and it has brought the peace in the schools, not in the rest of the society. So now I would like to add and conclude on that. Of course, among my friends in the academia, this proposal was considered as illiberal, attack on freedom, etc., etc. But among my compatriots, they say, what? It's nothing. A ban only in a public school? But I see all these scarves in the street, in the shops, and now the full veil. So they were furious. They thought the committee I was in, the parliament, have done nothing. So what did they do? They banned the full veil from everywhere except the place of worship. And the court, the European Court, accepted. The European Court endorsed the ban. On which reasoning? Because, I will come back to what Dieter said, the court normally had a jurisprudence that says there are different spaces. There is a Turkish case, Arslan, that says you can wear an uniform, religious uniform in the street if you are not a civil servant, because the person were not civil servant and they were in the street, there was no reason not to guarantee them their freedom of religion. So I thought the court could not escape saying the full veil ban is not in conformity with the European Convention. They They considered it in conformity. For which reasoning? The reasoning that was brought by a late colleague of professor of constitutional law, Guy Carcassonne, in front of the parliament. And what is the reasoning? What was the reasoning? The full veil has nothing to do with religion. They brought imams who says the Quran doesn't request the full veil. It's nothing to do with religion. It's a social norm. So let me give you an example. Imagine tomorrow there is a new religion coming in the US saying, God created us naked, we have to be naked everywhere. Everywhere where we go to class, we go to work, we go to the street, God, it's what God tells me to do, I have to do it. Whatever is the class. So what would the court say? Would the court say it's okay? Not sure. They will probably find a reasoning that will recreate this idea of private space, okay, a religious space, okay, but not the... So, this, based on the same reasoning, you could say, covering completely your body is like is the other extreme of being naked, and it's not acceptable in a democratic society not to show your face. And the court accepted that reasoning. What I would say to conclude, it is that the court have in some way resisted to the majoritarian pressure which has come in Europe against the Muslim minority in many ways. But nevertheless, there is a tendency of the European courts in the recent years. You mentioned your court decision on the cross, but the European court decided on the case Lauzi on Italy that the cross was cultural. And so didn't have the guts. I mean, they did it in the small chamber, but not in the grand chambers. And then, most recently, you mentioned the labor space. There is two decisions of March 2017 of the European Court of the Union for Luxembourg, who in some way balancing, but authorized in some circumstance the ban of religious sign in companies, when the people are in contact with the customers, etc., etc. So you have a tendency to restrict step by step the right to wear the scarf. That, to understand that, of course, you have the prejudice that exists. You have also, and Dieter mentioned it, sometimes the pressure. Many years after my committee produced a report, a man who was a general secretary of the Young Muslim Brotherhood wrote his memoir. And in his memoir, he said, at the time where we had our committee, we were campaigning, we had a campaign to go after the girls so they have to wear the scarf. It was our purpose. We have targets, we have schools, targets, etc., etc. That cannot be ignored. The governments, democratic government and the courts have to decide. We had that feeling that it was not individual choices, that there was an organization behind that. And so it is very complicated for the court and for the government to make decision in that context. But let me conclude with one story. I was part of a committee that was created by President Chirac. Why did he create this committee? It was because he was not trusting the parliamentary committee, because he thought the parliamentary committee would be too anti-Muslim, too anti-minority. He wanted a more balanced committee. And it was the presidential committee that, you might think we proposed something that was illiberal, but at the end, it was perceived balanced. And I would say that globally, the courts of Europe have tried to do their work as much as Dieter showed it by respecting some spheres, the separation between some spheres, balancing, hearing the different point of view, and it is what we have tried in different contexts, and hopefully we will continue to act, we will continue to go in that direction. Thank you very much.
I want to thank you both for your comments. They're very challenging for everybody here. We have time for just a few questions. Patrick is leaving at 8 o'clock to go to Paris. He just asked me to go with him, so I have to pack my bags. So just a few questions. Guido, wait, want to go to the microphone? She'll give you the microphone.
My question is, in a way, a very simple one. Does France or Germany make a distinction between headscarves, people who wear crucifixes, priests who wear clerical collars, nuns who wear nuns' habits? Can somebody in the workplace say, I will not have somebody who comes in with a crucifix? That is, I could understand a law that was completely the same across all of these, but it doesn't. Is that really what happens in France? Or is it only that we say that headscarves are somewhat different? Because I think that in the United States would not be acceptable. I hope so.
Of course, it's a general application, so it's all signs. For example, the ban on speakers' religious sign in public school applied to the kippah, and it was a big problem for the Sikh. But it applied to, and a big cross. So the only, what was authorized was something which called under the jurisprudence discreet, something you can put under your shirt for yourself. That's fine. But any other sign are forbidden in the French public school. Even the big cross and the Oh no, I mean, there are differences between spaces. The public school, I mean, for example, we didn't propose the ban in the university because if you keep the reasoning of pressure, an adult being pressured, a Muslim woman being pressured to wear the scarf can go to a lawyer, can go to the court when she is already at the university. It's not the same context than being 13 years old in a high school. It was the reasoning we had, that the minor children were in a different context than the adult. You might think it's not functioning, but from what I know from the American jurisprudence, for example, on some sign of the gang, you can exclude, you can ban some things in the high school. You have a special treatment for. And the other thing I want to say is that religion is so protected by the European Convention that if you want to limit the free exercise, you have to go through a law. The ban on the gang can be done by regulation of the school. The ban on any religious sign has to go through a national law because it's protected by the European Convention.
As I said, after the first decision of the German court, the states were under an obligation to rule, to have rules. And usually the rule was in almost all states, all religious symbols are prohibited for school teachers in schools. But there was the state of Baden-Württemberg, and they said the habit of the garment of nuns and monks is not regarded as a religious symbol. This is a professional dress. This was declared unconstitutional. More serious. After the crucifix decision that I mentioned, there was a debate in the German Catholic Church whether the Catholic Church should accept that the crucifix is no Christian symbol, but a cultural symbol in order to have it displayed, to continually have it displayed in public. I had some conversations with people who were discussing that, and I said, how can you do that without rejecting the very basis of your faith? Agreeing to the crucifix being not a Christian symbol, but a general symbol of the Occident is a negation of everything that the Church teaches. It didn't come that far, but there was a serious discussion. Do we have to pay this price in order to see the crucifix in schools?
If you want to ask a question, please line up to the microphone. As you're doing that, one question: to what extent can Sharia law be applied in local communities, even when it contradicts American law? Would you talk about that? The relationship of Sharia law to American law. And then please line up for questions.
There is no application of Sharia law in Germany, but there is a big discussion whether it should be allowed. And I think there's no solution about discussions like that, but there is a certain understanding. If Sharia law could be brought in accordance with the very essentials of the constitutional order of the state, then it might be possible to allow it. But probably in this case, it would no longer be Sharia law.
I think, Patrick, you're going to make your plane on time.
I just have one quick question, and it was just, you hadn't mentioned a burqa, and I would imagine that they would come under a different regulation because they cover the whole faith and identification. Is that true that the restrictions were less? I mean, would people just said no for those?
Frankly, I was thinking like you, that all the regulation that was preventing this person to enter first of all, often to have a job, to enter a bank, to enter many places where you have to show your face, was already a lot of restriction. And I didn't think you could, under the European Convention, prevent this person to go to a doctor or to go to buy food in a shop. If they still believe they have to wear the full veil, they still have the right to live. And I thought the full ban, for me, was unconstitutional and contrary to the convention. It's not what the French Constitutional Court decided. The court had a terrible decision in terms of rationality, because they say it has nothing to do with, there was an issue, the rationale of the European Court was to say it's nothing to do with religion. But the French court decided that there was an exception to wear the full veil in place of worship. So if it's an exception for place of worship, it means it has to do with religion. Otherwise, you don't create an exception for place of worship. So it was a complete contradiction. I mean, they wanted the ban on that, and they find a way to do it. But I think you are right. They could have limits the restriction to what were already the restrictions that were existing. I would like to make, because it seems we are ending more rapidly, I would like to make a comment related to, we had a few months ago, the French presidential election. And the polls have been made. How did the Muslim voted? And to the surprise of perhaps of some people, the guy who arrived, the candidate who made the top among the Muslims, were the most anti-religious candidates. Jean-Luc Mélenchon. Secularists, he wanted to forbid the member of the government to go to a country where the women wear scarf, to enter a church, the most anti-religious candidate. And he got the majority of the Muslim votes. So how do you explain that? And that is, I think, quite interesting. All of us, we are citizens, full citizens of a country. We are probably American, I'm French, Dieter is German. And we feel ourselves comfortable in our citizenship. We are also fully part of our national history. And if we want, if we make the choice, we can believe in God or not believe in God and change our mind on that during our life and change faith, etc., etc. But for my compatriots who are Muslim, their citizenship is often at stake. Their place in history is ignored, and the only place they are assigned to by the people who attack them, and sometimes also by the people who defend them, including themselves, is religion. And so if I have a wish about them, is that we consider them first, and it's because Mélenchon treated them as citizens, didn't mention their faith, didn't care about their faith, that they loved it. Suddenly they were not mentioned as Muslims. We don't mention the other citizens of France with their religion. Why this one? That was the colonial way of talking about these compatriots. And so I want, because we are here in a religious institution, I want to mention that we have to be very careful when we think about the minority in Europe, that first of all, their first wish is to be treated as full citizens of our country. And then they can be whatever they want, believer, non-believer, etc., etc., as much as us. And that is very important to keep that in mind.
We have time for one more question. All right. Harold?
I'll defer if you'd like.
We always make room for Harold's questions. Two more questions.
If the U.S. Supreme Court or courts uphold a travel ban that was originally called a Muslim ban, how much do you think that would, in the future, leave the door open for either Germany or France to follow suit on a similar ground?
A very quick answer. I cannot imagine that something like that had happened in Germany as it is now. Who knows what the future brings?
And there is another difference. I speak under your control. There is no plenary power of the executive in these matters. A refusal of visa under the Schengen can go to the court. And so that would be a very big difference.
Good evening. Thank you. Sorry. Thank you both for your talks. For Professor Grimm, I'm wondering if you could explain what kind of standard is applied in trying to decide whether something is considered religious or not, whether it's an objective standard that the judges try to extract from their analysis of the situation, or whether it's a subjective standard that is basically concluded from the personal beliefs of the people who are affected by it. Because, I mean, for example, the earlier question about Sharia law that was asked, I mean, the Sharia is not sort of a contained, clear code with specific provisions. So potentially, if, the state were empowered to intrude in prohibiting people from practicing Sharia, that would also include the performance of prayer within their private spaces, or the performance of prayer, or even the performance of ablutions, or even day-to-day matters that are considered within the broad rubric of the Sharia. So what sort of standard is applied? Because it seems that could be a potential pitfall in trying to adjudicate these issues. For Professor Weil, I don't know the statistics about how many of these incidents of bullying happen in the schools, and I'm sort of surprised that that alone was the instigation for the convening of the committee. But could you walk me through the logic of how, in order to solve the problem of bullying by a group of boys against a group of girls who don't cover their hair, the appropriate solution would be to pass legislation or to pass a ban that would inordinately disadvantage a completely separate group of girls who choose to wear the headscarf? Thank you.
In order to decide a case that is brought under freedom of religion, the courts have to decide, is it religion or not? This is inevitable, although it's extremely difficult. Because if it's not religion, purports to be a religion, then freedom of religion doesn't apply, maybe another fundamental right. But we have that with many fundamental rights. What is art? Yeah. We have a special protection of art in the German Constitution, and that means that everybody who gets with a song or with a play or with a painting into the danger of violating some rights, reputation, other, etc., tries to get under the roof of freedom of art. So it's inevitable to decide that, and this is the case in religion. But when the decision has been made, this is a case of religion, then only a subjective standard counts. That's to say, what a person, what a group finds, it is its religion, its religious command, religious belief has to be taken as such. The state has no power to decide what someone's belief is. The state is also not in a position to protect the orthodoxy of a denomination. Also, groups that deviate from the orthodoxy have the right to freedom of religion. So it is then a subjective standard. But to say it again, that something is protected by a fundamental right does not necessarily mean that it is permitted, because every fundamental right can be limited in order to protect other fundamental rights or other public goods.
Thanks for your question, which is very smart, and I totally agree that first side, your reasoning shows that to bring peace and order in the public school, we decided to ban if these girls wearing the scarf were not doing any trouble themselves, to ban them if they would continue to wear the scarf from the public school and they had to go to another school. That is absolutely true, and we had to make this choice because we didn't have any better solution. Now, I would like to add something because it cannot be understood what happened if you don't put it in the larger context of the French battle about the school system that was not very, that was even in the middle. The first headscarf case came in the middle of a battle that had started at the time of the French Revolution and only ended in 1995 after one attempt by the Mitterrand government to integrate the religious school under contract within a national frame, and that provoked 3 million people in the street. And then you had the attempt on the other side to give more money to the private school, and that provoked 3 million people on the street, not the same, 10 years later. And so there is this idea, especially among the teachers, who, I agree, confused the law, which is respecting all the freedom, including to believe, and the battle to reduce the power of religion in the mind, which is not laïcité, it's another word, it should be another word, there is this tradition of battle that make the teacher crazy if they see the presence of religion in the public school. And you have that context. But it's not linked to Islam. It is linked to the battle against the power of the Catholic Church in the mind of the kids. And so it is in that context that come the presence of a new religion. And the reaction is the same. And in fact, it ends with a solution that might be shocking the way you presented it. But let me tell you something. If you are a strong Muslim believer, it's not only the scarf you want to wear. It's also the Ramadan you want to do, all the religious holidays that you want to respect. And the public school can accommodate the main holidays, not every holidays. And it is why we have this system that functions for the Jews, for the Christian, and hopefully we have not enough Muslim school, but we will have more. And for the moment, the Muslim who want to practice completely, they respect their holidays, can do it. I told you, mainly in the Christian school. It's not a good system in terms of fairness and justice, but it is a system that has functioned since we proposed it to the Parliament.
I want to thank both Dieter and Patrick for being with us this evening and giving us much to think about going forward. We're both enriched by your presence tonight. Thank you very much for being here.